Hello guys, and welcome to another episode of our civil litigation mock trial course by the Daniel School of Law. And on today's episode, we are talking about the draft for our motion on notice for joinder and draft for our motion on notice for misjoinder of parties. How do we properly draft the motion on notice for joinder of parties, and how do we properly draft the motion on notice for misjoinder of parties, right? That means we want the court to strike out a particular person, right? Now, this is under our Module 3, which is parties to a civil action. Right? Now, this is also an area that frequently comes out in exam. Joinder of parties comes out, misjoinder of parties comes out, and third-party proceedings. In our next set of classes, we will discuss how to properly draft third-party proceeding, which, I hope you don't forget, is by motion ex parte. Do you understand that? So in this class now, we are talking about both joinder and misjoinder. How do we properly draft the both of them? And like I've said earlier, it is very important for your law school bar finals because it's likely to come out. It's one of those frequently asked questions. Might not be misjoinder, but for joinder, frequently asked. Do you understand that? So let's go into our class. Now, when you are drafting in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division, holding at Abuja. Now we want to draft that of joinder of parties, right? We want to draft that of joinder of parties. And I've told you that for every motion, now, what we just talked about now is the heading of the court. I've told you how the heading of the court must be. It is like this. In the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division, holding at Abuja, bam. Do you understand that? Now, if you want to know the court that you are supposed to bring a matter to, whether or not the High Court of Abuja or the High Court of Lagos or the magistrate court or whatever court you want to bring the matter to, how do we determine the court? You go to your class on jurisdiction, Module 2. You will learn it there. Do you understand that? Once you finish Module 2's class, you will learn it proper. Now, when we are talking about each motion that you are told to draft in exam, there is something peculiar that the lecturer wants to mark. And I will teach you that peculiar thing in this motion as opposed to the motion for misjoinder. This is the one for joinder. We'll talk about both of them in this class. So now we have talked about the heading of the court. What do we have after the heading of the court? The suit number. I told you that in every motion, there should be a suit number. Then after that, we have the parties. Right? We have the parties. Now, this is one distinguishing part for a motion on notice for a joinder of parties. Now, you have Gaba Bello, who is the claimant/respondent. You have Musa Dutse, who is the defendant/applicant. Now, before we go to this third part, which is Adaka Musa, when it comes to Gaba Bello and it comes to the other person being Musa Dutse, how do we know the parties to an action? How do we know the parties that are necessary for an action, for the determination of a suit? How do we properly draft the parties? All these have been discussed in my, class on parties. Right? Go through my class on parties because you see this part, it is very, very important. Go through my class on parties, Module 3, parties to a civil suit. I had about 20 classes on parties, if not close to 30, on parties alone. Go and listen to each of those classes so you know in what capacity you can bring an action, those who are supposed to be joined into an action, and how you properly draft those people. Please go and watch it. Now, in my class on interlocutory application, Module 8, I told you that when you are drafting When you are drafting an application, the person who is bringing that application, you must push /applicant in front of his name. The person who is to respond to the application, you must push /respondent in front of that person's name when you are drafting. I taught you all about this in our interlocutory application module 8 class. We have about 30 classes for that also. Now, let's take it a step further. We now talk about Adaka Musa, parties sought to be joined. The only time you have this double and, the first one is Gaba Bello, claimant, and Musa Dutse, defendant, and Adaka Musa, parties sought to be joined. You don't usually have something like this in draftings, right? One of the few times you have it is when you have a joinder of parties, as in this case, and when you have garnishee proceedings, which we discussed when we're talking about enforcement of judgment. Do you understand? We discussed it when we talked about enforcement of judgment, right? Which is our module, I think 16 or so, or 15. Right? So, now that we are talking about this, I want you to take note. In exam, there are 3 things that you must write. The claimant, whoever the claimant is, if it's the respondent or the applicant. The defendant, whoever the defendant is, if it's the respondent or the applicant. And there has to be a third party. That is the party to be joined. Do you understand this? Please, for the sake of bar finance, remember this. There is always the third line, parties to be joined. Do you understand this? Now, we then go to the next part, which is the motion on notice. The motion on notice. Motion on notice, then you say brought pursuant. Brought pursuant to Order 13, Rule 4 of the Abuja Rules, Order 43, Rule 1 and 2, and under the inherent jurisdiction of this court. I have told you severally that when we are talking about this brought pursuant to, there are 3 things that must be stated in it. The first one is the order of the court, the real one that told you to bring this application, right? Then the second is now the general order that says all applications shall be through a motion or notice or a motion ex parte. Then the third one shall now be under the inherent jurisdiction of the court. That is what they want to see in your bar finals. 3 things they want to see. Number 1 is the order that gives you the permission under which you are bringing these particular applications. You know, under the rules of court, there are so many applications that you can bring, but this particular one, there is an order that says I can bring it. What is that order? It is Order 13, Rule 4 that says I can bring an application. Then we now go to the second order, which is the general order for all motions that says that if you want to bring any application, it should be by motion on notice or a motion ex parte, and that is Order 43. So we have Order 13, Rule 4, then Order 43, Rule 1, then we then have to bring it under the inherent jurisdiction of the courts. I've told you also that because there are so many orders and rules, it is such that you can forget the rule. But if you want to aim for a first class, don't forget the order. Right? You can forget the rule. If you want to aim for best graduating students, don't forget the rule. But if you want to aim for a first class, okay, the rule can be forgotten. I think during my own bar finals, I don't think I carried most of these rules into the exam, right? And I got my A in that regard, right? So I believe that if you remember the order that gave you the permission to bring, then you now remember the general order, Order 43, and under the inherent jurisdiction of this court, you are fine. Provided that all other things are done properly, parties clause, you nailed it. Suit number, heading of the court, you've nailed it. And you want to go further now too and nail others too. So that rule might probably be a quarter mark or a half mark that you are letting go of. Do you understand? That's just the implication. That's why I said it doesn't deprive you of your A, but it might deprive you of your best grade. Do you understand? All those little details might deprive you. Now, moving on to the next. Now, we are now talking about the general thing that is in all motion. Take notice. Take notice that this honorable court will be moved on the dash day of dash 2019 at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel for the defendant applicant may be heard praying this court for the following reliefs. I have told you countless number of times, that when you are drafting motion, you must cram this thing. You can't run away. You can't. Where do you want to run and go to? Where? It's not possible. You must learn it. So you should just, in fact, at this point, each time I'm teaching my drafting class, you should just be reciting after me. Take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel for the claimant applicant may be heard praying this honorable court for the following relief, or as counsel on behalf of the claimant applicant may be heard praying this honorable court for the following relief, whatever way. Do you understand? So far, counsel, they hear for claimant applicant, for on behalf of the claimant applicant, still works. Praying the court for the following reliefs, same thing. Do you understand that? So when we are done with that, we now go to our order. We are asking for an order of this honorable court joining Adaka Musa as the second defendant in this case. Simple. He no had. But what they want to mark, the major thing they want to mark is the body of your motion. And then that party sought to be joined. That party sought to be joined. For joinder of parties sought to be joined. Please don't forget it. Please, you don't join it and say first defendant, second defendant. No, he has not been added as the second defendant yet. So you cannot say second defendant. What you will now say is claimant, then defendant, then party sought to be joined. And. You must put that and between them. Do you understand that? So your order will now say an order of this honorable court joining Adaka Musa as the second defendant. Do you understand that? Then you now have your omnibus order. Your omnibus order is as for such further order or orders as this honorable court may deem fit to make in the circumstance. What is the implication of this omnibus order? And why do we have it in all application? I have taught it already in my interlocutory application class, module 8. I've taught that already. Why we have this omnibus order? I've taught it already, so we shouldn't go back and be rehashing things. Then we have dated this dash day of dash 20 dash. Your dated is another mark. And then you have, because it's a motion on notice, not only are you supposed to sign, you are supposed to have on notice too. A motion on notice too. But when they are originating processes, then you can say for service on. You can also say for service on too. It doesn't change anything actually. But on notice too is better for application, right? You can also say for service on. I think I've used for service on too. On notice too, for service on is the same thing. So when you are signing, your name first, your chamber next, then who you are representing, your address, your email, your phone number. Your name first, your chamber next, who you are representing. Are you for the claimant applicant or you are for the defendant respondent? Who are you for, right? So you say claimant applicant cancel, claimant cancel, defendant respondent cancel, whoever it is. Do you understand what I'm saying? Right? So in this case, we are the defendant applicant cancel. Number 1, Broad Street, Ikeja, so and so. And on notice 2, the claimant respondent through his cancel, Alachi, blah, blah, blah. You put his name, his firm, his email, his address. Please, you see this order that I'm teaching you. Cram the order the way it is. Cram it like that. I beg you. Please, cram it. Once you can put this order the way I have taught you how to draft motion for joinder, once you can put it in your head, you are doing a lot already. Now, let's go to our misjoinder. When we now talk about misjoinder, right, we are using the one of Lagos State as an example, right? So, in the one of, Abuja, we have in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division holding at Abuja. Lagos is in the High Court of Lagos State, in the Lagos Judicial Division holding at Lagos. If you want to know the jurisdiction of the court to bring the matter to, watch my Module 2 on jurisdiction. then we have suit number, and then we have between. Now, I want you to see something here. We have two claimants and we have two defendants, Abi. Now, did you see party sought to be struck off? Here, party sought to be struck off. There is nothing like party sought to be struck off, as we had party sought to be joined in the one for Joinder. There is nothing like party sought to be struck off in the one for Misjoinder. Do you follow? Right? So we still have the claimant applicant and the defendant respondent for the both of them. Then we now have our broad pursuant 2. Now we have order 15, rule 16, order 43, and under the inherent jurisdiction of this court. Right? I've already explained this already. You bring under 3 things. This one now for Misjoinder, it is order 15, rule 16 of the Lagos rules. So you have to bring it under the Lagos rule that gave you the permission. Then under 43, the general, and under the inherent jurisdiction of the court, right? Now, we already know that too, right? Now, we now talk about the take notice. We already understand this take notice part. It's the same for all motions, right? Now, an order of this honorable court striking out the name of the second defendant / respondent as a party in this suit. Can you see the difference? Can you see the difference? That one says an order joining Musa Adaka. He named the person as the second defendant. This one said an order striking out the name of the second defendant. He didn't need to mention because the court already knows the name. It is there. In the case of Musa Adaka, the court did not know the name. So you have to say joining who? Musa Adaka as the second defendant. This one, we are striking out the second defendant. Do you understand? Because the party has been misjoined. He ought not to have been joined. So there should be a motion on Otis to remove the party. And that is why we have this in this circumstance. So you can see what is the difference between the motion for joinder and the motion for misjoinder. Let's start with the heading of the court. Is there a difference in the heading of the court? No. They are the same thing, depending on the court that you are taking it to. Is there a difference in suit number? No. Is there a difference in parties? Yes. When you are joining, you have to have 3 layers, right? The first layer, claimant. The second layer, defendant. The third layer, party sought to be joined, right? Do we have the same thing for misjoinder? No. We only have the normal 2 layers, the claimant and the defendant. Do you understand that? The claimant and the defendant. Don't forget to put your /respondent /applicant. In the case of joinder, is there /respondent for party sought to be joined? No. It is just party sought to be joined. So that's our first difference. The second one, let's continue now. Is one motion on notice and the other motion ex parte? No. They are both motion on notice. Okay. Broad pursuant too. There might be slight differences there too. Because the one that gave you the power to join might be different from the one that gave you the power to strike out. So you should take note of that, right? And also take note of it for the respective laws. The one of Lagos State rules and the one of the Federal Capital Territory rules. Take note of that. Then we'll now talk about the general order, order 43. 1 and 2 for Abuja, but order 43, 1 of Lagos. Then under the inherent jurisdiction of the court. There is no significant difference there in terms of drafting. It's just the orders that will change. Okay, take notice. Is there a significant difference there? No. But now when we now get to the order, is there a significant difference in the way we couch our order? Yes. Because when we are joining, we mention the name of the person that we want to join. And we say joining so and so person as what? As the second defendant. In joinder, we say joining ABC Musa Adaka as the second defendant in this suit. In misjoinder, we say striking out the name of the second defendant as a party in this suit. So what changes is in the party clause and in our order clause. Our order, how we couch it, and our party clause. Those two things must change. Every other thing remains significantly the same. So we still have our omnibus clause, which I've taught you the nitty-gritty in our interlocutory class module 8. We have dated this dash day, then we have signature and all that on one part, and we have the for service on the other part, or notice to on the other part. They are the same thing. They are the same thing. So once you can learn the way a motion is drafted, you will realize that the only thing that you just have to change is the peculiarities of each motion. Do you understand? The peculiarities of each motion. So for the one of Misjoinder, what is the peculiarity? For the one of Joinder, what is the peculiarity? Once you understand the peculiarity of each of them, you would not have a problem. And then lastly, just to look at how the affidavit is supposed to be, let us see the same for motion for joinder. You will see that the parties are frankly the same thing. The heading of the court, everything before we talk about affidavit in support, they are the same thing. You just copy and paste your this thing for joinder. The way you put everything for joinder, put it in your affidavit in support until you get to that point where it says affidavit in support for motion on notice for joinder, right? And don't forget that I told you that after you have talked about that affidavit in support, the next thing that you do is ngaoka. That is I, then N being what? Your name. You write the name of the person I want to depose to the affidavit. The next thing being what? The G, the gender. What is the person's gender, male or female? The next thing being what? A, adult. The person is an adult. The next thing, O, what's the occupation of the person? The next thing being what? K, C, citizen. Is he a Nigerian or Nigerian, whatever? The next thing being what? A, address. So, Ngaoka helps you to write out that part of your affidavit. The preamble, I, then you now write your Ngaoka. Do you understand? Do hereby make on oath and state as follows. Or do hereby make oath and state as follows. I told you that you can also add religion into it. Is a Christian or Muslim, whatever it is, right? If you want to. And then you draft your affidavit. On how to properly draft this affidavit, I have stated it in several classes, particularly my Module 8 class, which is on interlocutory applications. So please, you can watch that to be abreast of it. Then after you have stated your paragraphs in your affidavit, you can then look at the deponents. The deponent signs in the right-hand side, sworn at the High Court Registry Abuja, dated this dash day and before Commissioner of Oaths. That is the structure of how you draft. Your structure of how you draft. This is what I intend to teach in this class. So please take note of the points that I've made. They are very, very important. Take note of each and every of these points. They are very, very important. And I hope that you've enjoyed the class for today. In our next class, we'll talk about third-party proceedings, right? We'll talk about third-party proceedings, which also is an area that frequently comes out in exam. So I will see you in my next class. Please have a very wonderful day.